Hello everyone. Can we all hear me? Good afternoon or good evening rather.
Can hear you, sir.
Good evening, sir.
Yeah, good evening. Thank you all for joining. Welcome to class. So we will be starting class right about now. Sorry about the flyer. We are in week 3 of the JIIPCC Mentorship and Internship program and not week 2. I later realized after I had set up the flyer. But all the same, welcome to class. Thank you so much for joining. Please, I would like for us to reach out to our co-mentees so that they can be aware that class has officially started, and then we can just continue. We can just continue with the session, but we'll not be wasting any time. It's already 4 o'clock. So what we'll be doing, just to give us a run through of the agenda, what we'll be doing today is that we'll be taking presentations from you guys firstly in class today. We'll be having your presentation. Then after presentations from mentees, all right, we'll take mentors' presentations, and then we'll take feedbacks from mentors' presentation and feedback, and then we'll take questions and call it a day, right? So just to reaffirm the mentors we'll be having in class today. We affirm the mentors we'll be having in class today, as we have had in the last few classes, right? We'll be having Mr. Rakesh Sharma and Miss Amosa Shukurat Modipeola, right? So they are going to be our two mentors for today who will be helping us run through what we have planned out for the day. So we'll be starting out now, right? We'll be starting out. So we'll commence with presentation. We will commence with presentations from the mentees. All right. So the group presenter, I hope the group presenter is in class today. Can you kindly go ahead, share your screen and start the presentation? And then once you are done, we'll take mentor's presentation and carry on with the rest of class. Please, you can go ahead. Do we have the group presenter in class? Can we hear me? Do we have our group presenter with us? Please confirm if you guys can hear me. Hello, can we all hear me? Okay. Is there an issue with my network? Please, can anyone hear me? Can we confirm that we can hear me?
Yes, I can hear you. I can hear you. Sorry, I'm late.
Oh, okay. All right. So please, we would like to have presentations once again. All right, so we'll be taking your presentations firstly in today's class. And then after we're done with presentations from you guys, we'll be taking mentors, discourse, their feedback, and we'll be taking questions and we'll call it a day. So please, let's kindly go ahead and start the presentation. You can go ahead and share your slides and, let's just hear your discourse and what you have planned for us in today's session.
Okay, thank you very much for this opportunity. Let me share my. Mm, okay. I'm sorry for the delay. So today, our topic is, I don't know if everyone can hear me.
Yes, we can
Can you
hear
hear
you.
me?
Yes, we can hear you.
Okay, thank you. Thank you. So our topic today is preparing patent application, parts of patent application and patent drafting. Then please, I will just go, because of the delay and everything, I'll just go straight forward like into the presentation. And then our introduction. Patents provide inventions by granting inventors is exclusive rights, that's rights that do not have any, is just their own personal rights. It's not right that has been intervened or will have any intrusion for anyone. So exclusive rights allows inventors to control, use, and commercialize for about 20 years. That's these inventors are allowed to do whatever they want to do with these rights. Yes, they're allowed to maybe like maybe sell, or they're allowed to give any other company, or yes, any other company rights to use this particular patent for maybe a period of maybe 10 years or so, according to their own contract and agreement. And these inventors will collect maybe an amount of money. They can sell and they can loan, um, however they want to actually utilize this patent. Yes, drafting is both legal and technical. Is both legal and a technical exercise requiring clarity and precision. So when you are drafting a patent, it is very important that you are there should be clarity, and then you should be very precise when you are drafting a patent. Yes, it's a legal exercise and also a technical exercise. A strong application must be novel, it should be new, inventive, clear, and should comply with statutory rules and regulations. Okay. So preparing the specification. Specification is the heart of a patent application. Yes, it includes, so according to this, yeah, specification, we're talking about specification. I think specification is more about what makes your product different, or the product that you have a patent on different from other products that they have patents on, or other things, all those other patents that are out there. What makes your product unique? What makes it different? What makes it peculiar? It must describe the invention in a way clear enough for a skilled person to replicate it. That means not necessarily, yes, duplicate it. So in your specification, you must describe that particular invention. Maybe Coke, to be precise. They should have a patent on it. And then in that particular this patent, that what makes Coke different from maybe BD Coke or other products, that all those black drinks, it has to be very particular about it. Yes, this particular ingredient, this particular thing. Yes, drawing and diagrams are examples strengthen understanding and support claims. So if it's maybe a machine, a diagram or drawing has to be made. Yes, to make it to make that particular specification to be properly understood, or to actually support claims. Then I don't know if you have any questions or anything I'm supposed to elaborate on, please do well to ask me. Let's talk about drafting guidelines. When you are drafting a patent, what things you are meant to focus on? The first one is clarity. it's very important that you use simple, consistent, and precise technical terms. It's very important that you don't use ambiguous words. Use words that most likely straight to the point, words that will help you. It's not words that are confusing or can imply other things. Use very simple terms and be very consistent. Like when you're talking about maybe the measurement of a particular thing, be very consistent about that particular measurement. Be very precise, precise technical terms. Then when you are drafting a patent too, there should be this completeness. You have to cover all aspects. Okay, I used Coke, for instance. That's a drink. Let me use maybe a food product, this particular food product, or maybe let's say cookie, this particular unique cookie that you created and you want to draft patent on it or whatever it is. Yes, you have to be, let it be very complete, like your description in your specification, let it be complete. When you're drafting the patent, it has to be complete. You have to talk about maybe if it's 2 spoons of flour, or maybe probably you use this particular type of sugar, or you get the sugar from this particular place. That unique recipe, you have to say exactly how it is. Remember that in specification, it should be I know a skilled person, maybe a skilled cook, since I'm using cookie to be precise, has to be able to replicate that particular thing following your instructions. So the in drafting a patent, the guideline in that drafting a patent, that thing has to be very complete. Yes, it has to be very complete and it has to cover all aspects and all verification of that invention. Claims must be broad enough to protect. So when you are making we are drafting a patent, it must be broad enough to protect that particular patent and not too broad to overlap into any prior acts, maybe other patents that have been created. So when you're drafting a patent, you have to make sure that, yes, I'm drafting this patent to cover this particular patent that I'm drafting, but it should not overlap into any other patent that have been created. Yes, you must have done your patent search. So you know that, okay, this product is out there. Yes, and what makes your own products different from other products that they have patents on. Yes, patent rights on. So you, and considering that, you draft your patent. Yeah. When you draft it, you have to make it broad enough to cover that particular patent, considering the fact that maybe you're in court and then yeah, there is an argument on whether your patent has this is right, is valued and everything. Yes, your patent has to be broad enough, and also it should not overlap into any other patents, right, that have been created before your own patent. There should be a balance. Then the filing requirements. Filing requirements. Applications must follow statutory and procedural rules in each jurisdiction. The jurisdiction could be like in Nigeria, yes, it's a jurisdiction. Maybe in Nigeria we have Enugu jurisdiction, yes, different places. So when you are drafting a particular patent, when you are making application for patent right and whatever, you have to consider the rules in Nigeria. Okay, how do we actually do this in Nigeria? Or maybe you want to create something international. Maybe you now begin to consider, based on this particular patent, how do I want to draft? Based on the particular patent rights that I'm going for, how do I want to draft it? How do I want to file it? You have to file it in accordance to that, in accordance to the rules of that jurisdiction you are going to go under. Yes, if you are going to draft that patent, you're going to file for a patent right in China, the rules could be very different from Nigeria. In fact, most likely very, very different, based on the fact that Nigeria can be, or maybe America, based on the fact that Nigeria can be a little bit, I would just say, underdeveloped in some aspects. Yes. So requirements includes proper formatting, numbering claims, and structured drawing. Yes, I talked about drawing before. Then abstract and description must comply with word and style limits. When you are requirements for filing a patent rights, yes, making application for that, they could have requirements for word and style limits. So you have to follow all those requirements when you're filing, making applications for patents rights. Then deadlines for filing and renewals must be covered to keep protection valid. Deadlines for filing and renewals has to be covered to keep the protection valid. Yes, because if maybe you have patent rights and everything, and you need to renew, and then probably you did not keep to the date for renewal, and then something happens, there could be an issue that could evolve or come up from that particular um, inability to file on time for renewal. Yes, so we have to consider all those things. Then we come to prosecution process. After filing, the patent office examines the application for novelty, inventive step, and clarity. So after you file, then the patent office will begin to examine your application for novelty. Okay, is this new? Is this yes, is this peculiar? Is this just coming up? Yes. Then inventive step, and then clarity. How clear, share your application. How clear is this? Is the application ambiguous? Is it just vague? Then examiners may issue office actions with objection or rejection. So after they finish checking your application, they can issue office actions with objections to, okay, your application, I object to this particular thing. Maybe they could have questions about maybe the measurement of this particular thing, and probably they saw a product like that, or they're not seeing how good, I mean, probably this is not new at all. Okay, I've seen this product in the market like this, like this. They could have objections to it or rejections. Applicants must respond by amending claims or giving clarifications. So applicants must you have to, because you are going after, yes, patent rights, you have to respond by amending your claim or giving clarification to that particular claim. Then successful prosecution leads to grants of patent rights. So when you are done with everything, it will now lead to the successful grant of your patent rights. So these are the steps that you have to go through. First of all, you file, and then the patent office will examine the application for novelty, inventive step, and clarity. Then the examiners will now, after examining the application, they will issue objections or rejections to that particular application. They could, yes. Applicants will now, you then, after applying for that particular patent rights, will now have to respond to probably the objections or the rejections. So you can respond by amending your claims or giving clarifications to that particular to your application. Yes. Then successful prosecution will lead to the grant of patent rights. Then let's go back to the conclusion. Strong patents require careful drafting and compliance with the legal rules. I talked about jurisdiction. Yes. So when you are drafting patents, for it to actually be strong, you have to it's very, very important that you consider the rules of that particular jurisdiction that you are applying for. You're applying under. If it's in Nigeria, the particular rules that could guide it. Yes, I can't just bring up one law and draft it like that, because when I come to defend, or not necessarily defend, or persecute, or bring up someone that is invading on my rights, it's that law that will guide that particular claim that I'm bringing up. Yes. So it's very important that I consider the rules, the statutory rules or regulation concerning patent rights in that particular country. America, those rules could be really, really different. So maybe not really, really, but they can be different, and then it's very important. Then also consider the different so also consider balance between clarity, technical accuracy, and legal protection. Yes, that balance between clarity, technical accuracy, and legal protection is very important. Then patent protection promotes innovation and rewards inventors. When you protect your patent, it promotes innovation. And yes, it promotes, in fact, it will encourage you based on the money you could be getting out of it. Yes, because if you commercialize it, a lot of people get they see it as a means of profit or income in their own company. They could even be doing it as their own work to just innovate things and then sell their rights, yes, to people. It's a very good source of income, at least I believe that. Then it also rewards inventors, sorry. It rewards them. Yes, it encourages it too. Then proper drafting reduces rejection risks and ensures enforceable rights. When you properly draft your patent, it reduces rejection risks. And then, yes, because when I was talking about the prosecution process, I talked about the examiners issuing office actions with rejections and objections. So, but when you properly draft your patent, considering making it broad enough to cover your patent and not too broad as to go over to another patent, making it showing its uniqueness, making it clear, simple, consistent, and precise, I believe it will reduce rejection objection by the examiners. Yes. And then it will also ensure enforceable rights because you have properly drafted it. So when you are going to court, even the people that maybe they infringed on your right, they are trying to bring up a good defense. They may not really have that leverage, or sorry, they may not have that opportunity because the patent is properly drafted. Yes. Don't know if there's any question or anything I should elaborate more on, but I believe we're done.
All right, thank you very much, Gucci, for making that presentation, that wonderful presentation on behalf of your group. We say a big thank you to the team for putting it together. And yeah, well done to everyone. So kindly, we would like to ask for a few minutes, right? We would like to ask for a few minutes. So I think we're trying to work on getting our mentors on the call. Mr. Rakesh is having a little bit of a technical issue, so please, we would just like to take a few minutes to do that. We would like to take a few minutes to kindly plead for a few minutes to do that so that we can carry on with the class. So please, just a minute or two. I will get back to you guys once we are able to get him on the call. Thank you. Hello everyone. Sorry for the small silence. Right. We had to work on getting Mr. Rakesh on the call, and I can see he's already with us. Thank you so much, sir, for joining. We are happy to have you in today's class. Yeah. Sir, we have already received presentations from the mentees, based off of the topic that was sent to them. Right. And we want to just also hear from you based off of what you have prepared for us in today's class. We'll take your discussion, and then we'll take questions and call it a day, sir. Hello, Mr. Rakesh.
Thank you, Dennis, and apologies everyone for joining late. I was in another meetings, so this was the reason of delay. So I am extremely sorry for everything.
No problem, sir.
Yeah, and our today's discussion is this one, the preparing patent application and parts of patent application, right?
Yes, sir.
Okay, so in patent application, as per the slides that we have already discussed, that these are having all different sections that are required as per the law, and it is changing from country to country. But one thing I would want to emphasize that is most critical. Can anyone name that from the patent application or the parts of the patent application, what is the most critical element? Can anyone name? It's an open question for all the audience.
Sir, please, could I get the question again?
Okay, so from the patent application, which includes multiple parts like title, abstract, summary, drawings, claims, and detailed description, out of all these different parts, what is the most important part of a patent application?
Sir, I think it's the claims because they define the scope of the protection of your invention, what
Yeah,
your patent is actually
absolutely
protecting
right.
and what you gain back.
Absolutely right. So why claims are important?
Sir, because what you do not include in your claims, you cannot protect and you cannot stop others from using.
Okay, that's absolutely right. So in that case, if claims are most important, then what is the significance of other parts of the patent application, which includes the background and summary and drawings and detailed description and multiple other embodiments? So what is the significance of all other parts? Feel free to share your thoughts.
Possibly,
Yeah.
okay. Sorry, sir. Possibly to just serve as, let me say, just giving more explanation as to your invention and to help in all the tests, the substantive tests and um, technical tests as well. That's what I think, sir.
Okay. Any other guesses? You are partially right.
For possibly testing patentability.
Yes, you are partially right. Any other guess? Any other person from the audience who want to share their thoughts? Yes, no?
Sir, for me, I believe that other parts of a patent, apart from the claims, is more like elaborating the claims to make it broad enough to show more about that particular patent. Yes, like the drawing,
Mm-hmm.
make it more specific.
Okay. So, because it is a legal agreement, we are signing with the government. We are sharing our invention, and government is in exchange providing us a protection for 20 years. Consider it as a utility patent. So, what we are sharing, so it is the requirement from the law that what we are sharing, that information we are sharing about the invention should be clear and sufficient. So, because of that, this is the requirement from the law that these all fields should be described in such detail that any person, hear it very carefully, that any person who is having ordinary skill in that art should be able to understand it and create it. So that is most important, and this is the reason we have to describe each and every section of the patent application. So we would want to start from the as you have mentioned, claims are most important. We will discuss it at very last. But what about the background section? How you should write it? Whether it should be very broad or it should be very narrow? What are your thoughts? And what is the significance of background section, first of all? Anyone? Am I audible to everyone?
Yes, sir, we can hear you. I'm just thinking of a really good answer.
Okay. Okay, okay. No problem.
And okay, so for me, a background section is actually the place where you show that your product is new. Yes. Show that your product is different from other products out there. Yes. For me, yes. That's what I think
Okay.
the background section.
Okay. So can we include anything that is new in our invention in the background?
I don't think so, sir.
Okay. So what should be included in the background, and what are the features that should not be included in the background? Anyone?
Well, I
Feel
don't
free.
think exact. Hello?
Okay.
Well, I think the background should just describe the um, current technology in that field that already exists and just possibly explain the need for that new invention, the problems, what the limitations the prior arts encountered, and basically, yes, the need for the new invention, and should probably not contain specific details of the invention you want to patent.
Totally agree, actually. That is a very wonderful response you have provided. So, background is just setting up the stage. It helps us in understanding the current problems and need for a particular solution to resolve that particular problem. And for background section itself, if for particular domain you are writing your patent, consider suppose electronics domain or electrical or software today like AI/ML. So it all depends on the domain you are handling and the preferences of your client or the attorney. But on a generally level, I will want to say that if the domain is very crowded, like there are so many patents, then you can proceed with a detailed background. But if the domain is very new and there is not so much development or patents involved in this domain, then you can go with a very broad background section. It all depends on the domain you are handling or the type of technology you are handling. It is not a thumb rule or a requirement from the patent office or particular jurisdiction, but you must have to decide accordingly. It all depends on the situations and the scenarios you are handling. There is no one stop solution or one size fits all policy. It all depends on the type of client as well as the type of technology you are handling. Got my point?
Yes, sir, we did.
So how it will be beneficial? Suppose if you are writing a broader background, it will be having sufficient information for your novelty to prove. But if you are dealing with some kind of crowded technology domain where there is already so many active applicants and so many patents already filed and granted, and then if still you are going with a broader one in the background section, then chances of getting the prior art rejection would get increased. But if you are having a very narrow background, sticking specifically to a solution which you are disclosing in your claims, then examiner who will be doing the patentability search, he might avoid all such other irrelevant prior arts, and rejections uh, would be less, and chances of getting it grant quickly would be more. Got my point from this perspective? So it's all about the game of psychology, that you must have to not only sticking to the technology itself, but you must have to keep your thinking broad enough to think from these perspectives also, the technology you are handling and how much crowded it is. Accordingly, you will have to find out a broad or narrow scope. Is it clear?
Yes, sir.
Yes, sir.
Okay. So talking about the other most important part of the patent application, which we have already said, it is claims. So in claims also, there are a variety of claims, including independent and dependent claims. So based on the type of technology, how will you decide what type of claims we should protect and what type of claims we should not write? Do you have any idea? For example, suppose I'm giving you an example of this CCTV camera. Consider MI 360-degree camera, which is capable to rotate 360 degree, and it is connected to Wi-Fi so that you can access it anywhere across the globe if you are having the internet connection. So have you heard about that camera? CCTV camera connected to Wi-Fi, and it is rotatable and you can access it from your phone from anywhere. Have you heard about it?
I
Any
believe so,
CCTV?
sir. Yes.
Yes, sir, we have.
So everybody might have seen some kind of CCTV camera, and that is connected to Wi-Fi, and you are using your phone. You can access it from anywhere by using internet connection. Everybody is aware about this technology, this product.
Yes, sir.
So for this particular invention, consider a new client comes to you with this invention. Do not consider it as already available, but consider it as a new which is not available in the market, and you have to write claims for this. So what type of claims you will write? From method, apparatus, system, or CRM? What type of claims will you write to protect this invention? This is the question.
I don't think I know, sir.
I don't think, but so to protect this invention, will you write only the apparatus claim, method claim, system claim, or CRM claim, or all type of claims? This is my question.
I think I'll write all, sir.
All type of claims. But what is the reason behind that? Can you explain a little bit more? I want to make it more interactive. That's why I am asking more and more questions rather than telling what I knew. I want you people to think from all these perspectives, and this is the reason of asking the questions. Otherwise, if what I knew and I am simply telling, it will be revision for myself. But I want you people to think. If you will write all different types of claims, then what is the reason for it? If client asks you, then how will you respond to the client? Why you have written apparatus, method, and system claim? What will you say?
Okay, from my own perspective, sir, I would do all parts of the claims. I would do so because I want every piece of the invention to be protected. So let's say the 360 rotation. I would want the claim to cover that, including the Wi-Fi and also whatever transmission that it will cover, so that it's not just one part of the invention that is protected, but all part of it.
But what will be the benefit of protecting it from all sides?
Sorry, I didn't get you, sir.
So you said I will protect it from all sides. So what will be the benefit of writing all type of claims?
I really don't know whether I'll be wrong, sir, but benefit based on definition that was given before, at least the contribution just now, I want to protect it from all sides of claim, just in case maybe another technology comes up that maybe does not really rotate through internet but uses Wi-Fi. I want to come up through that particular area. Then I think that's why I'm protecting it from all sides, like using all types of claim in this particular scenario. Don't know.
I agree. Protecting it from all side will help, but how it will help? What will be the benefit you will get from it? What will be the ultimate benefit? Let me
Okay.
rephrase it.
Okay. So I believe I will be able to commercialize maybe one particular.
We want
I'm serious.
So I believe I should be able to commercialize one aspect, maybe um maybe the Wi-Fi or just this. I believe the essence of patent is to protect your invention and then to have the ability to commercialize it. So maybe the Wi-Fi aspect, I can commercialize it, or maybe the protecting, I can give a company access to that particular patent, only them. I believe that's the essence of creating that claim.
mm-hmm.
I'm not really sure. Yes.
Okay. So one thing that I would like, everyone has given me the right answers. Just I am summarizing it by using different words. So if you are protecting it from all perspectives, patents are just like the landmines. Okay. And that are being used to protect your territory. So what you will consider, landmines should be more or less? If you want to protect your borders, will you have more landmines or only very few?
More, sir.
So if somebody by accidentally or intentionally puts their feet on the landmine, what will be the repercussions? Can anybody tell?
They won't. I don't think they will be alive anymore. They will feel
But no, if somebody is putting their feet, then it is fine. But if they are lifting it, then it will get triggered. Okay.
Yes,
So
sir.
putting a feet, then only if you knew that there is a landmine, then you can defuse it because you are the owner of that landmine. Got my point. Don't consider it literally as exactly the same landmines. Consider it from patent perspective. So in the same way, for that Wi-Fi camera related application, if you have four different landmines, that is apparatus, method, then system and CRM, and then out of any of these four, if somebody is trying to make, use, sell, or import. These are the four categories actually. If somebody is making it, using it, selling it, or importing it from all these different perspectives of the claims, which is falling in this realm of these four types of claims, then they are intentionally or unintentionally putting their feet on your landmines. And then to not get those landmines triggered, either they have to pay you the royalty fees. We call it a licensing fee. Otherwise, if they are not willing to pay, then you can go to the court and ask them to pay the royalty. Got my point? So this is the ultimate objective and it is related to the business and business is related to the profitability. That how you can get maximum profitability out of your patents, out of your inventions. It is by stopping others. Is it clear?
Yes, sir. It's clear.
Otherwise, I am giving you another analogy that is even much more helpful. Suppose you own a piece of land where you live or you are having multiple rooms that you can offer for rent. That multiple rooms are similar to multiple patents that you can offer in the form of technology, and you are able to offer it for renting purpose for the others to use it. So if you are offering your room for some strangers, just like in a guest house or in a hotel, so they charge it for daily basis. So in the same way, for your own technology, you can charge as a royalty fee, but it is only possible if these are protected. It means you are having patents for your technology. Otherwise, you cannot charge anybody for anything which you do not own. Is it clear?
Yes, sir.
So
Yes,
the
sir.
room I am talking about, that is a tangible property, but the patents we are talking about are the intangible property, and that's why we call it intellectual property that you have created for either yourself or for your clients by using your mind. So from the parts of the patent application, we have discussed about the background as well as the claims. So now if we have to shift around the detailed description, it includes two things. One is the drawings and the second is the detailed description of the drawings along with multiple embodiments. Clear? So if I have to ask you all one very simple question, that what are the alternative uses of a uh, ball pen, and we have to list down 10 uses at least. Can you list down 10 uses of a ball pen? Any kind of uses apart from writing. Can you name 10 uses of a ball pen? How you can use it differently for different purposes? Can you name it?
I would say one of the uses of a ball pen, aside from writing, would be the straight edges of the pen can be used as a form of, would I say, ruler, right? You can use it to draw lines
Agree.
using that.
Awesome. So ruler is one use. What are the others? Feel free to talk. Just be open, be innovative.
So I think some people just hang pens on the pockets of their shirt to, I don't know, make the home aesthetic look a bit better, I believe, or official. Some
Okay,
nurses do that actually, yes.
agree. What are the other ones? This is second use. Can we use it as a straw to drink some kind of beverages by removing the refill and the spring from it
Yes,
by
sir.
some
That's
minor
another use.
modification?
That's
Can we
another use.
use it?
It can be used as a straw.
Can we use it as a weapon if somebody attacks? Because it is a sharp
Yeah.
ending it is having.
Yes, that's another. We can use as.
And can females use it to tie their hair also as a knot and to put it as a pin in the hair
Yes.
actually by
Yes,
tying?
the cover can be used as a toy too. Some do use some children they do use the cover of a ballpoint pen
Exactly,
as toys. Yes.
exactly. And the spring can be used in multiple other ways. The refill can also be used, and the outer cover can also be used in multiple other ways. Got it? So this is what we are discussing. What it is the detailed description of something we have mentioned. Suppose you have invented a pen. So the noble features of the pen are the same, that you are using it for writing purpose. Novelty might be lying around the either the refill or the ink composition or the type of roller you are developed. So this is all the main invention, but what we are discussing, the alternative uses of it, is the different embodiments. Got my point? So
Yes, sir.
why all these different embodiments are important or are helpful? This is the question now.
Sorry, come again, sir.
So why all these alternate uses of something apart from the main use are essential? That pen is used for writing, but we are discussing the alternate uses of the pen. We call these different embodiments. You might have heard about the word embodiment. So embodiment means different features or different applications that could be possible. Okay.
I guess it would be so that another person will not develop a prior art based off of an alternative use of that invention.
That is the part from the novel part, what we are discussing, that should be in the claims. But if claims are novel, you can include all those additional features in either the dependent claims, and you can also write all these embodiments in the detailed description itself, or you can introduce it in the drawings itself. Why? Because if somebody is trying to make or use your invention in all these different variations, nobody can do it. And if still they are doing it, they must have to pay you the royalty. Is it clear?
It's clear, sir.
So this is the objective which you must have to think, and you must have to write it by considering all possible uses of something, all possible applications of something, and you must have to write it from that perspective. Right?
All right.
Yes, sir.
So the last part I want to discuss, that is the most important one, is although claims are the most important, which we are discussing, which we had already discussed, that is the drawings. So what kind of drawings or what type of drawings you should include in your invention? Anyone?
So I think drawings that describe or give an illustration of the function aspect of the invention. So basically the invention and stuff in it that makes it work.
Mhm. So what type of drawings will you use? So do you consider drawings are more important, or by writing few additional paragraphs in the detailed description are more important?
I
I
think
think
the drawings
writing
are
is
more
more
important. I
Pardon?
think the drawings are more important. It
Why?
it 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 it, it illustrates it better when it's in drawings than when we are just writing when the description. But when the drawings should be detailed and illustrate more the process and uses to which the patent can be can be put into. So I think the drawings are more important and more descriptive of what the invention is about. So I think the drawings are better and more
I
important.
agree. I agree. What was the response from the other member? Can you please share?
Okay, I was saying the writing in the description to me is more important because drawings are not are not actually deemed as necessary parts of the patent application. That is to say that if you don't have, it's not like if you don't have drawings in your patent application that it will be totally disqualified. It's only where necessary that people add drawings. So that's why I believe that it's better to include some certain things in your description as opposed to drawing.
Okay. So if what if I will say you both are right and you both are partially wrong as well? So have you heard one that quotation which says a picture is worth of thousand words?
Yes, sir. Yeah.
So
Yes, sir.
from that perspective, if you think that drawing is having multiple embodiments, multiple features, and we are not writing it in the description, then you can use it for your patent protection. It could or could not be applicable considering different scenario. The scenario one is uh, that you have mentioned that drawings are important but not writing in the description, and the another scenario is you are writing it in description but drawing it is not available. But I would say to have a balance of these two is much more beneficial always. Why? Because if you have something which is shown in the drawing, if it is having unique like normal or ordinary function which everybody knows, okay, this particular element will be working in only the this manner itself, then if you are not writing the description itself, it is acceptable because it is evident. Suppose in your drawings you have mentioned some kind of a lock and a key, and you have not written anything around that lock and key, and everybody knows if you insert the key and rotate it, it will unlock the lock. It is self-evident. Got it? Or a light bulb and a switch and the power supply, and everybody knows it is self-evident. Once the power supply will be on, then the light bulb will glow, and once power supply will be cut off, that bulb will not glow, that electric bulb. So those are the features which are evident. For all these, if you are having the drawings, but you are not writing anything in the description, then also it is acceptable. Clear? Yes
Yes,
or no?
sir. Yes, sir.
But for anything that is having the novel features of your invention, where you are using some kind of elements, suppose some kind of refrigerator or some kind of a encoding block, where you are inserting some kind of information, and after processing it is providing you something else, then if you are not writing it, it is not self-evident because nobody will be able to interpret it in that same manner. Clear? So in that case, if you are reflecting it in the drawings for in essential or the critical features of the invention, no matter if it is displayed in the drawing, but you have not written anything in the specification, you cannot take advantage of all these features because examiner will use it according to his own interpretation, and you cannot defend it because you have not written anything related to those features or those components. Got my point?
Yes, sir.
Yes,
So
sir.
this is the criticality of drawings for all like routine features or the features which are well known. Feel free not to add the description if you are do not want, but all the essential, critical or novel features always describe in the detailed description section. Then only you can take the advantage of those. Otherwise, you won't. So any other questions anybody has for me to ask? Feel free to ask.
Sir, please, could you explain like fundamental differences between your description and your claims? And is it possible for you to write something in your claims and not put it in the description? And if that invalidates your patent application?
No. If you are writing anything in the claims and it is not supported in the description, then you will get a rejection from the examiner. This is the requirement from law, that sufficiency of disclosure. In USA, we call it 112A, and in Europe itself, there is a rejection related to the same. And in your jurisdiction, Nigeria also, there might be a rejection related to the same, that whatever you are writing in the claims, all those terms and all those features should be explained in detail so that anyone having ordinary skill in the art should be able to understand it and create it. You cannot keep it ambiguous or indefinite.
Okay. Thank you very much, sir.
Otherwise, all the big tech players, all the big tech giants, they will never disclose their inventions, and they will try to keep or create a monopoly of all those things they are doing. And ordinary public, you can say, or the universities or the research scholars would not be able to understand actually what their inventions are. And it will stop the innovation in the society, and it will stop the healthy competition itself.
Okay, sir. Thank you.
So this is the ultimate objective. So one thing which I was trying to demonstrate throughout my discussion, can anyone tell what was the whole objective of my today's presentation? Anyone? In one word. Or what you have learned from my presentation in one word, if I have to ask.
If I'm to choose one word, I would it be possibly protection?
Okay.
Because that's what I basically got. Patent application protection.
Others?
I would say detailed narration.
Okay. Thank you. One more feedback and then I will let you know. Please.
Sorry, sir. May I have asked it? I have a question.
Please ask.
Sir, please, earlier when you were when you gave an illustration of CCTV camera, I'm sorry,
Your
my
voice,
line.
your voice is little bit breaking and having a noise. Can you just check your sound settings and ask again, please?
All right, sir.
It's
I
now it's clear.
All right, sir. When earlier when you gave the example of CCTV camera, my line was breaking, so I couldn't really get some of the things you were saying before it got clear about the
Okay.
types of claim like that do you make. I didn't really get those types of claim that we can make or protection. I didn't get it when you asked about the CCTV that are we going to apply for a whole claim or a whole protection or something. You mentioned different types that we can apply for. So I want to know what types, those types of protection that you mentioned. I didn't get it.
So it is all possible types you want to cover. Suppose to cover that camera itself and its 360-degree rotation, you can cover it under the apparatus claim. Or if you are having some kind of software related patent that you have developed some algorithm that it is capturing the images, it is identifying the faces also, then a method will also work on the software, and a CRM claim, computer readable media. And for the third feature, we were discussing that you can connect it with the Wi-Fi and you can access it from anywhere. So a system claim would be sufficient. So this was the opinion that how and why you should cover it from all different perspectives.
All right, sir. I got it.
Got
Thank you,
it?
sir.
It
Yes,
is
sir.
similar to creating a boundary wall of your house so that
Alright, sir.
nobody could enter without your permission from anywhere. And if somebody is entering from the main gate, they must have to pay the royalty because it is full of the landmines.
Alright, sir.
Okay.
Alright, got this.
And
Thank you, sir.
coming to the same question again, what was the in one word, if you have to summarize our today's discussion while writing a patent application or while writing claims or backgrounds or detailed description, what is the one thing that should come in your mind? That is my question to you. What is the one thing that you should always keep in your mind?
Um, I would say different types of patent application protection or claim.
Okay, that is also right. So you all have given different perspectives. So I would want to say thanks for this. But the one thing that should always come to your mind that I was trying to demonstrate, the one thing that I did today is I asked you all people, what is one thing that I asked you all? What is the one thing that I asked you all people on different sections? These are questions. What I asked you all people? Different questions. Agree or not?
Sorry, sir, we did not really get. Please, can you come again?
Okay, so in my today's session, what I did or I demonstrated, I asked you all people different types of questions.
Yes, sir.
And by asking those questions, you people think it from different perspectives and try to give the answers, right?
Yes, sir.
So
Yes,
this
sir.
is one thing that is much more important above everything, that is asking questions at each and every stage. So this is one thing, if you will adopt, you will become a better patent professional. You will be able to assist your clients. You will be able to handle all the inventions very beautifully. Only one thing, that is asking questions and asking right set of questions at the right time. Got
Noted,
it?
sir. Yes, sir. Sir.
It- Did it make sense?
Yes, sir. Yes, sir.
Yes,
Yes,
Because
sir.
if without asking any questions, if I would have discussed everything with you, do you think that would be beneficial? Or now by having your opinion, we had a discussion that was more beneficial? What do you think?
Asking question was not beneficial, sir.
Yes. So
And
this is one thing I am just trying to convey, so that whenever you are dealing with the clients, you should ask questions itself to get more and more clarity.
all right, sir.
Got it? So
yes, sir.
from the parts of patent application, this is what all I was having for discussion. But whenever we will be having the next sessions, then we can discuss about the different sections like the claim writing and what type of claims and why we should write. We will discuss all these things in detail then. Till then, I would want to say thank you to everyone for making this session interactive and asking so many questions. I really appreciate that.
All right. Thank you, sir.
Thank you so much, Mr. Rakesh, for the session. Thank you so much for trying to get us to respond and to think critically about the different aspects of or the different parts of a claim of a patent, of patent drafting, right? We really, really appreciate you pushing us in that direction. Thank you very much, Mr. Rakesh. So far we have gotten Mr. Rakesh's discussion. We've also asked a few questions. So I think it is safe to say that based off of the intention we have for class, we have been able to cover it. All right. So please, I would like to kindly encourage us to turn on our videos. My location is quite dark, but I don't know if you can see me clearly. Please, let's turn on our videos for a quick screenshot, and then we'll call it a day in class. Hello, can we all hear me? For the mentees, can we hear me? Please, you can kindly turn on your videos so that we can take a quick screenshot and call it a day.
Do also need to turn on the camera?
Would really appreciate that, sir. All right, thank you, Aisha. Thank you, Muna. Thank you, Semisayo. Thank you, Victory. Thank you, Mr. Rakesh. It's nice seeing you. Yes, sir. All right, so we are done with that. Thank you, everyone. Thank you, everyone. So we've officially come to the end of today's class. I really hope that we have gotten to learn everything that I said. I really hope we have gotten a few things from everything that has been said and shared by Mr. Rakesh. Please, I would like to kindly encourage us to revisit this class, right, to get the presentation that was made, and also to revisit this class to get the presentation that was made, and also the discussion that we've had, and what Mr. Rakesh has shared, right. Next week we'll also be treating patents. I think we'll be treating patents claim next week, right? So kindly look out for the tasks for next week. Let us put in the efforts to ensure that we get our our presentation ready on time. The list or description of tasks will be shared, I think, tomorrow morning, right? So let's look out for that. And thank you all for being in class. And please do enjoy the rest of your evening. Thank you so much, Mr. Rakesh, for being with us.
Pleasure is all mine. So thank you everyone for making it interactive. So thank you, Dennis, for moderating it so well. I really appreciate the active participation from everyone and always happy to help. And feel free to reach out to me, anyone, in any case needed anything additional to discuss. Always happy to help.
Thank you, sir.
So much.